Claire's mother had always said the estate would be split equally. There was a will, one Claire had seen, one that had been executed with two witnesses 3 years before her mother's death, that said exactly that. 3 weeks after the funeral, her brother Thomas produced a second will. This one was dated 8 months before the death. This one gave Thomas 80% of the estate and Claire 20%. It had two witnesses. It appeared notarized. Claire had never seen it. Her mother had never mentioned it, and something about the signature felt wrong.
Forensic document examination is a field that courts take seriously when the examiner is qualified. Claire's probate attorney referred her to a court-certified forensic document examiner with 24 years of experience and a history of testifying in complex fraud cases. The examiner's job was not to say the signature was forged, it was to analyze every measurable characteristic of the signature on the disputed will and compare it to known authentic examples from the same time period.
The examiner's report identified 7 specific measurable discrepancies between the signature on the disputed will and authenticated examples of their mother's signature from the same year. Variations in pen pressure, inconsistencies in the starting stroke, abnormal line quality suggesting copied rather than natural movement, inconsistent baseline alignment, and irregularities in 2 specific letter formations that their mother had consistent habits for. The examiner's conclusion: the signature exhibited characteristics consistent with simulation rather than natural writing.
Thomas's attorney retained their own forensic document examiner who submitted a report finding the signature consistent with the decedent's authentic writing. The probate court judge ordered both examiners to testify at a hearing. Claire's examiner testified for 2 hours and demonstrated the 7 discrepancies on enlarged images projected in the courtroom. Thomas's examiner testified for 45 minutes and was unable to explain 3 of the 7 discrepancies under cross-examination.
The judge ruled the disputed will invalid. The original will, splitting the estate equally, was admitted to probate. Thomas was ordered to return $43,000 he had withdrawn from estate accounts following the disputed will's submission, plus attorney's fees. The judge referred the matter to the district attorney's office for potential investigation of will fraud. As of the hearing date, that investigation was pending.
The thing that made Claire's case strong was the comparison material. Forensic document examination requires authentic examples to compare against. Claire had kept every card her mother had ever sent her, had the original executed will, and had 2 years of her mother's personal correspondence that had been stored at Claire's home. The examiner had abundant material without those reference documents. The analysis would have been impossible to make conclusive.
The forged will had been notarized, which the examiner and attorney noted was itself potentially fraudulent if the notary had not witnessed the signing. The notary's records showed the notarization was performed via remote online notarization, a process that had become available in their state only 18 months before the will's purported date. The judge found this detail combined with the handwriting analysis sufficient to support the invalidity finding. Keep every card, keep every letter, keep the document subscribed